Good morning. Yet another criminal case, fantastic case, 2012. Near about 3 persons were murdered, political rivalry, due to political rivalry, and 21 accused were included. And thereafter, a trial had taken place. Lower court convicted some of them, 11 accused, and others were acquitted. So the convicted accused preferred appeal before the High Court of Madras, and complainant filed appeal against the acquittal. Both appeals were dismissed. The Supreme Court has set aside the judgment of the trial court as well as the High Court and acquitted, stating that by entertaining criminal appeals under special leave petition, Article 136, they have got power not to, they say there is no prohibition for reappreciating the evidence. Yes, what all are the grounds is most important. The judgment is very fantastic. This is AAR 2025, Supreme Court 2674. AAR 2025, Supreme Court 2674. Agniraj and others versus state represented by CBC. Number one, first thing they say, one of the eyewitnesses was not reaching police station for days together, and he is roaming, and he is not properly informing the police about the number of accused involving in the offence. Number one. Number two, one of the eyewitnesses says he witnessed the occurrence from the bush, but the prosecution did not say that what was the distance between the bush and the incident. And the Supreme Court disbelieved the evidence of this witness, stating that it's not acceptable. You would have seen the occurrence by car light. Then about what happened, a eyewitness, a child witness. The child witness claimed before the court that she is seeing the accused first time before the court. And the testimony of the witness not recorded properly as to how the child understands the importance of both. Therefore, the identification period was also not conducted. That was another ground. Then important ground that some of the accused were implicated by tracing the fingerprints available over the car in which deceased were traveling. But the Supreme Court says this is a new ratio, says they would have taken the photographs of that fingerprints and Panchanama about the fingerprints available over the car. Therefore, that also disbelieved. Then they say simply the left out evidence was only recovery of weapon. And they say by recovery of weapon alone, conviction cannot be imposed. So they set aside the judgment. Best judgment, you must read it. I can only refer this much, not more than that. I hope you understand the importance of this judgment. This is AAR 2025, Supreme Court 2674. Anurag versus others versus State of Deputy Superintendent of Police, CBC. And the problem was the rivalry was 4 times the accused party were elected as Panchayat Board President. Subsequently, the deceased seems to have won the elections. That resulted the death of the deceased. Along with the deceased, some 3 persons were also killed. What a fantastic incident. And finally they got acquitted before the Supreme Court for the lapses on the part of the prosecution. The cases was conducted by Basant Siddharth Agarwal, Manu Krishnan, Srinivasan, P. Srinivasan, Amit Anand Tiwari, Sabri Subramanian, Devyani Gupta, Vishnu Unnikrishnan, Tanvi Anand, Sausiriya Havelia, Janvi Taneja, Rajan Misra, Dani Saipal, Vaisal Tyagi responded. So the state advocates who conducted trial before the High Court as well or the clients have no faith on the Tamil Nadu advocates. Best wishes.